Alright, February 9th, 2026, 3:30 p.m. I got back around noonish from visiting the courthouse and dropping off this motion, which I drafted over the weekend with the help of my assistants of counsel. So it's a consolidated motion to dismiss for lack of jurisdiction, for statutory immunity, for structural constitutional violations. With prejudice, by the way. So you can read it here. It's going to come in different sections. I think 1 through 10, I believe. So 35 points or something like that. I did it with the help of AI, and didn't take too long. Point 1, criminal prosecution cannot proceed unless a plea has been entered, thereby joining the issue. This is all being generated, of course, because I got Judge Johnson to admit and claim and order, really, that we are, in fact, proceeding to trial without even having a plea entered on the record. Yes, you heard that correctly. You're welcome. Let me just take a bow real sec. There you go. Oh, that felt good. All right. No plea of guilty, not guilty, or otherwise has been entered by Mr. Pierce on the record in this case. Point 3, on February 5th, 2026, in open court, the presiding judge, well, when I say presiding judge, I mean presiding of that hearing, expressly acknowledged, of course it means that hearing because it mentions that hearing on February 5th, acknowledged that this matter is proceeding toward trial despite no plea having been entered. The prosecutor and court security officers were present. Point 4, in the absence of a plea, no lawful issue has been joined and the court lacks jurisdiction to proceed. Jurisdictional defects are non-waivable and render further proceedings void. Section 2 is denial of a speedy arraignment and a speedy trial. Now, I came up with this speedy arraignment. I just think it's funny. It's like you say I have a right to a speedy trial. I can't even get a speedy arraignment, right? Point 5, Mr. Pierce was arrested over 1 year ago, and the underlying incident occurred over 16 months ago. Despite this passage of time, Mr. Pierce has not received a lawful and meaningful arraignment, and no plea has been entered on the record. Now that is in fact a true statement, as in actuality, there was no moment in time where a judge, in my presence, entered a plea on the record. If it was entered outside of a hearing, and obviously I wasn't there, I would have no knowledge of it. Therefore, that would still be a true statement to me. Because of the limited knowledge I have, I don't see what judges do behind closed doors, obviously. 7.7, the failure to provide a prompt arraignment has deprived Mr. Pierce of notice, issue joining, and the ability to assert rights in a timely and lawful manner. Point 8, the prolonged delay between arrest, blah, blah, blah. Point 9, the denial of a speedy arraignment, blah, blah, blah. I don't need to really, it's not about this, it's also about just recording it, right? So that's delaying the speedy arraignment. It just goes into why. Here's the absolute statutory minimum. Came from the State Bill 148, influenced by, inspired by, you could say. There's a Missouri Revised Statute 1073.033. And these are key points. Missouri law provides an absolute defense, statutory defense, for a person who kills or injures a dog when the dog poses an imminent threat of serious physical injury. Mr. Pierce was on his own property and acted to stop an imminent threat. Point 13, where an absolute statutory defense applies, criminal liability does not attach as a matter of law, and prosecution is barred and to be compensated if it occurs. Look at that revised statute. It's pretty amazing. It does, to some degree, of course it's always left vague. Well, a judge has to think that it's imminent harm, and with the pictures on the ground and the consistent testimony and all this YouTube stuff and all the case net court filings, I've been saying one thing and one thing only, that was imminent danger, and I even explain it as to how dog psychology can develop this way based on the claims of the dog owners about, oh, this dog is so friendly, it roams around the whole neighborhood, everybody loves it. Anyway, yeah. And then point 13, where an absolute statutory defense applies. Yeah, compensated if occurs. That's crazy. Section 4. This was my doing. corrupt judicial removal and continuing obstruction. Point 14. The presiding judge of the St. Charles County Courthouse unilaterally removed Judge Sandcork from presiding over this case without providing Mr. Pierce any notice, explanation, or opportunity to appeal. Mr. Pierce had been working with Judge Sandcork for over 1 year, and this abrupt removal caused substantial prejudice to the defense, disrupted case strategy, and violated principles of fair process. Keep in mind, they didn't give a reason whatsoever. No valid excuse, no made-up excuse, no lie, no... I mean, it's just so obvious for the corruption, but of course they don't reason what specific point or what mistake did Judge Sandcork make that got him off the case, right? They don't mention that at all. Just like they don't mention that they removed my social security number from the O'Fallon CaseNet file. Thank you very much. Finally, after what has been over 3 months of having my social security number on the public website when the form itself says it shouldn't be on there. Anyway. The replacement Judge Johnson has actively prevented inquiry into the reasons for Sandcork's removal. This opaque transfer raises strong concerns of judicial corruption and bias and directly impacts Mr. Pierce's ability to receive a fair and informed proceeding. Short, sweet, to the point. Section 5. Suppression of exculpatory evidence. Brady violations. Point 15. On the date of the incident, law enforcement body-worn camera footage captured a male civilian witness who stated that he heard aggressive barking before hearing a woman screaming, supporting the existence of an imminent threat. This witness was known to law enforcement on the day of the incident, yet was not followed up with, disclosed, or included by the state. Guarantees not on the witness list. Point 17. The dog's owner's 911 call is in possession of the Wentzville Police Department. Mr. Pierce made a sunshine request for this recording and has written confirmation of its existence and possession. It has not been produced. The CD that I got from Murphy during the hearing on February 5th that he just handed to me after the hearing was formally closed, the envelope said 911. That was the CD that had only my call on it and not the dog owner's call on it, and that's the call I need, of course. So I just gave it to him. I gave him that CD. I have no use for it. I was like, here's what you gave me. It's my call, not the one I requested. If you're giving it to me because I went to the Wentzville cops. That's the only reason why you would. I went to him yesterday, or 2 days prior to you giving this to me. Like, I want the call from them, not me. I don't even need my call. I already know there's nothing in my call other than I didn't want them to get in trouble, which is kind of nice. But I need their call, hello. So, point 18, the 911 call is contemporaneous, unfiltered, and potentially exculpatory, capturing panic and spontaneous statements prior to any coordination or narrative shaping. 19, body-worn camera recordings produced by the state mute or omit, unroute police audio, and truncate the response, suppressing contemporaneous radio traffic and spontaneous statements. Point 20, knowledge of police is imputed to the prosecution. Suppression of unknown material, exculpatory evidence violates due process under Brady v. Maryland. The resulting prejudice is structural and cannot be cured. I mean, it just gets me irked just to read this stuff. Bad faith investigation. Just look, the body cam footage is... don't even get me started. I can't believe don't even get me started. Section 7, denial of the right to assistance of counsel. You can all read this. It's just so silly. I even had a no-kidding real lawyer that cost money volunteer to be my lawyer for free in the middle of a hearing. And because Judge Sandcork would not allow him to be my standby counsel, and I had to sign the document that says he represents me fully, meaning the court gets jurisdiction unchallenged by me. I just signed something that says this court obviously has jurisdiction because, look, I just signed to be represented by a lawyer to interact with this court, to be imposed upon by it. That's not crooked at all. There it is, offered legal services without compensation. He said, for whatever Mr. Pierce wants to pay, is what he said. Section 8, denial of a record and procedural fairness. This courthouse does not create an audio recording of proceedings and has threatened incarceration for attempts by Mr. Pierce to preserve an audio-only record. Point 28, Mr. Pierce was prevented from recording a recent hearing under threat of jail, resulting in the permanent loss of a record of critical admissions. Point 29, proceeding without a record while denying any means to preserve one violates due process and forecloses meaningful review. What kind of lawyer wants to hire a client when he needs the judges to be nice to him so he can have a successful career? And you can look at CaseNet and says the judges hate him, and then the client says, yeah, the judges won't let me make my own audio recording so I can bust them breaking all the rules. When I just ask them simple clarifications, it should just be a simple yes or no. We can just all go about our lives here if we just answer yes or no. If the prosecutor sent a piece of mail to you, it's all I'm asking. Section 9, undisclosed filings. If you look on CaseNet, Murphy put in a limine, motion in limine. I can't click on it. I can't see it. That's an ex parte communication between you and the judge. I can't see it. What's on it? How am I supposed to prepare for a trial if I don't know what's in your motion in limine, Murphy? Do they not teach you anything in law school these days? Like, did you just use whatever to get by? I don't even... How do you... Jeez. You're handing me discovery documents and then filing a motion in limine that I can't see to the court while I don't have assistance of counsel within 12 days of a forced 3-day jury trial. I wanted 2 weeks. You wanted 2 days. The judge gave me 3, and I was not allowed to protest the issue or argue for more. You were there. You heard it. Point 31. Proceedings predicated on undisclosed filings deny notice and the opportunity to be heard and are void. Section 10, cumulative structural failure. It sounds like something you'd hear on the Starship Enterprise, and that's exactly what this is. Point 32, each of the foregoing grounds independently requires dismissal. Point 33, collectively they establish a prosecution that is jurisdictionally void, statutorily barred, and constitutionally irreparable. Wherefore, Mr. Pierce demands that this court dismisses all charges with prejudice for lack of jurisdiction, denial of speedy arraignment, and speedy trial. Absolute statutory immunity and absolute defense and structural constitutional violations. Defendant reserves all rights and remedies, including civil claims for violations herein described. That's it. Let's see what they do with that.